Welcome, everyone. Thank you for joining to another VIC talk. My name is Andrei Quintia Pastrana. I am a postdoctoral researcher at the University of Groningen and a member of the VIC team, which is hosting this event. In the VIC project, we're looking at the right to adequate housing as a bundle of rights comprising of access, occupancy, and exit rights. In previous VIC talks, we have discussed various issues concerning adequate housing and evictions. To shed some light on access to housing, we have today with us Damian, who is professor at the University of Alberta and director of the Community Housing Canada Research Partnership. Professor Collins is a human geographer who focuses on issues of housing and homelessness in urban contexts. He has an extensive background in the Canadian Housing First experiences and has published on the topic in relevant journals like Housing Studies. He will talk today about Housing First policy and practice and how it is possible to operationalize the right to housing to evaluate policies and programs. He's joining us today from New Zealand. So, good morning, Damien. Thank you very much for waking up so early. You will have now around 40 minutes, and we can have later some questions. So, the floor is yours whenever you're ready. Thank you very much.
Thank you very much, Andre, for the warm introduction, and good evening to everyone in Europe. It is an early morning here in New Zealand, but I'm very happy to join you. I will speak for about 40 minutes on the topics that Andre discussed, and then I'm very happy to have some discussion, which is often the best part of a presentation. So I'll just move to my slides now, and I'll see you all again on screen soon. Okay, so here we go. Yes, so the overarching title for today is Realizing the Human Right to Housing, Housing First and Policy in Practice. And I should acknowledge, first of all, that I'm working at the University of Alberta in Edmonton, Canada, and that my work is funded by SSHRC, the Social Sciences and Humanities Research Council in Canada. So traditionally in Canada, we start with an acknowledgement of where we're working, the land on which we are situated. And of course, that is always something that is dear to a geographer's heart. So I'll go ahead and do that. So I work in Edmonton, as mentioned, a city of 1 million people, with an additional 400,000 people in the greater metropolitan area. So about 1.4 million in total. The traditional Cree name for what is called the city of Edmonton is Amiskwesi Weskahagen, which translates into English as Beaver Hills House. A wonderfully evocative name, referring to the creature, the beaver, that has so fundamentally shaped the human and cultural landscapes of the Edmonton area. Edmonton and the region of Alberta in which it's situated are under treaty called Treaty 6. And that was signed between the Canadian Crown and the First Nations people of the area in 1876. And today, Edmonton is home to many First Nations peoples, as well as the Métis people, another Indigenous group in the Canadian context. And I am, delighted to work on that land, which has so much meaning to Indigenous peoples. Having said that, although Edmonton is a place of great beauty and opportunity, it's also a harsh landscape in many ways, and famously harsh winters. And currently, there are 3,105 people who are homeless in the city of Edmonton, including 712 who are living outside. And referring back to the point I made originally about the Indigenous meanings of the land, substantial percentage, in fact, approximately half of the 3,105 unhoused people in Edmonton are of Indigenous background. And so we see in Edmonton, as in so many other places that have experienced settler colonialism, that Indigenous people are, at greatly increased risk of homelessness. So what I'd like to do today is three things. First of all, something I hope will be of interest to you all. I'll just briefly describe the current status of housing rights in Canada and how they've changed quite dramatically since 2017, but since 2019 in particular. Then in a slightly unorthodox move, I'll then move back in time, talk about the Housing First model and its adoption in Canada, which began in 2007. And then the third and final point I'll make is with reference to my substantive research, where together with colleagues, I attempt to evaluate Housing First from a right to housing perspective. And as Andre mentioned, and as the title of today's presentation emphasizes, there were two components to that. First, evaluating Housing First policies, and secondly, evaluating the practices at the front line of the programs that were actually interacting with homeless people, bringing them into housing, supporting them to remain housing. And so we're really looking at, I guess, both sides of that particular coin, both the text and the practices that accompanied Housing First. So let's get started on the first topic, which is the current and indeed the changing status of housing rights in Canada. And I think it's actually quite a positive story. I know often when we think about housing rights, there are many problems, many negative issues to deal with, but here is a pleasant change perhaps from that story of the right to housing beginning to be taken seriously. So let's have a look at that. So if we think back to, before 2017 in particular, what was the status quo for housing rights in Canada? In one of the articles that I'm drawing on today, we referred to it as a challenging terrain, so a geographical metaphor, I guess, that reflected the very adverse conditions for people seeking to advance the human right to adequate housing. So let's have a brief consideration of why that was. First of all, the dominant or most relevant part of the Canadian Constitution in this context is the Canadian Charter of Rights and Freedoms, which was adopted in 1982. And as you can see here, it has been interpreted by the courts and ultimately by society more generally as a negative rights instrument. So it's very much about constraining the state, about limiting the intrusions, quote unquote, of the state onto the freedoms of individuals and groups. And because it's been interpreted in that very traditional, liberal, negative way, it doesn't impose positive duties on the state to meet the social, economic, and cultural rights of citizens. And consistent with that interpretation of the Charter of Rights and Freedoms, it was a very influential case in 2014 called the Tanajaja case. And that was heard at the level of provincial courts in Ontario. And it found that housing rights claims were, quote, not justicable. And so I think that's really interesting. Often on the legal side of the right to adequate housing, we do directly consider that question. Is it something that can be brought to court? Do individuals have the right to bring a case arguing that their right to adequate housing has been breached or is not being acknowledged? And in this case, the courts answered that very directly with the answer no. There is no individual right or even a group right to bring claims before the court. And a quote that very clearly illustrates that dominant perspective from this case: no positive charter obligation which required Canada and Ontario, the province where the case was heard, to provide for affordable, adequate, and accessible housing. So really imposing a very direct barrier to anyone that's seeking to bring this issue to the courts to seek judicial relief. That was essentially closed off. And that decision reflected the status quo, reflected the circumstances at the time. And those circumstances included a very limited recognition of economic, social, and cultural rights in domestic law. In fact, there was, those rights, I would say, were largely unknown outside of a handful of lawyers and on the housing side, housing advocates. And when it was mentioned that these rights existed in international law, there was considerable skepticism, even dismissal of the concept that they had any application at domestic level. So a challenging terrain indeed. I should say briefly that although the Charter of Rights and Freedoms is very much a negative rights instrument, it has certainly been associated with considerable social progress in Canada. An example of that would be the right to marriage equality, and many other rights for sexual and gender minorities have been secured under the Charter on the basis that the state cannot discriminate between different types of relationships and different types of gender identity. This situation, that context that I described, changed radically in 2017 when the federal government, under the leadership of Prime Minister Trudeau, adopted the National Housing Strategy. This was really a hallmark social policy, and by that I mean, when the history of the Trudeau government is written, it will emphasize that this was one of the major changes to the policy landscape and the legal landscape that government introduced. And indeed, it was Canada's first national housing strategy. We were, until this point, one of very few high-income countries that did not have such a strategy. And the United Nations Special Rapporteur for the right to adequate housing had urged Canada to adopt precisely this type of overarching policy framework. As you would expect, it sets many of the targets that you would hope to see in a housing strategy. And it's also an umbrella for multiple funding streams and programs whereby the federal government funds provinces, municipalities, smaller organisations to undertake housing-related developments. I should note that those funding packages are not static, and in fact, since the National Housing Strategy was adopted, the number and the monetary value of those programs has expanded dramatically. And critically, for our purposes today, it is embedded in a rights-based approach. Let's have a look at what that means. So, Chapter 1 of the National Housing Strategy, I always think, what goes at the start is the most important, albeit informally perhaps. And that chapter is called Housing Rights are Human Rights. And this is the first paragraph. Canadians deserve safe and affordable housing. That is why the federal government is taking these additional steps to progressively implement the right of every Canadian to access housing, adequate housing. Our plan is grounded in principles and will contribute to, among other things, the International Covenant on Economic, Social and Cultural Rights. So here we see many of the elements of the right to housing making their way into federal policy. First, that it's something that people are deserving of. It is an entitlement of all people. Secondly, the progressive realization of the right, consistent with how it's interpreted at the international legal level. It's not something, of course, that can be completely guaranteed overnight, but it must be realized progressively over time. It's a right that is universal. It is held by every Canadian, and it is grounded in principles and in international law. And I suspect some of you are asking the question, where did this come from? Why did the federal government take such a step that was out of keeping with how the right to housing had been considered in Canada until this point? And I don't really have an answer to that off the top of my head. I think that research remains to be done as to why the federal government decided to take this step and to really transform the housing policy landscape. To its credit, the federal government followed up the National Housing Strategy with the National Housing Strategy Act, a statute that really put many of these principles into law. And I thought I'd share with you Section 4 of that Act, called the Housing Policy Declaration. And in it, the federal government declared that its policy included the following. A, the right to adequate housing is a fundamental human right affirmed in international law. Second, that housing is essential to the inherent dignity and well-being of the person. And then number D here, that progressive realization of the right is recognized in the international covenant. So here we see, really bringing international law into the domestic legal framework in a very direct way that had never been undertaken before. So, what can we consider to be the strengths and limitations of the National Housing Strategy Act? So here, starting perhaps with the limitations, this is regular legislation. It is not entrenched in law. And what that means is that future parliaments in Canada could amend or even revoke this law with a simple majority. Although I suspect, attempting to repeal the law would be unpalatable with the electorate at this point. I guess it follows from this that it does not give housing the status of a constitutional right, and the government did not reopen the Constitution to include the right to housing. Thirdly, consistent with historical practice in Canada, it does not appear to provide for individuals to bring individual claims to court, although that is yet to be tested. And lastly, and I think, in contrast to several countries in Europe, most notably France and I guess outside of the European Union, but in the geographical area, Scotland does not create a duty to provide homeless people with housing. Nevertheless, I would say, it certainly contains some strengths. That the direct references to international law, bringing those into a domestic statute, as I mentioned. It requires the minister to maintain a national housing strategy and to make sure that that strategy is grounded in a human rights-based approach. The current strategy is a 10-year strategy, and so in 2027, a new strategy or an updated strategy will be released, and it is required under statute that the minister do this, and that the new strategy rather refers to rights. It also creates a structure around the minister, including a National Housing Council and an independent National Housing Advocate, whose role is to research and examine systemic housing issues independently of the government. And I would say that as the National Housing Advocate has started their work in recent years, they have had a great deal of respect and cooperation from civil society, and especially from housing advocates and people with lived experience of housing need. Here's an example of one of the more recent pieces of work of the Housing Advocate, a review of homeless encampments, a very common phenomenon in Canadian cities, reflecting a homeless crisis, but one that has seldom been considered through a human right to house lens. And when the teaching semester is over, I look forward to reading this review. As yet, time has not permitted. But just a little example of the types of work they're up to. So moving on to my second point, thinking about housing first. And I would say I suspect that many of you have at least some familiarity with housing first, partly because it's now over 30 years old, and partly because of its relatively widespread adoption in many European jurisdictions. So let's briefly recap. Housing first emerged from 1992 as a radical alternative to previous approaches to homelessness, which, at least in North America, emphasized emergency shelters and then a gradual re-entry into housing that was conditional upon the behavior and in particular the compliance with treatment and commitments to reducing alcohol and drug use amongst homeless people. So it certainly did not provide a direct access to the human right to housing. It was a slow and conditional process, conditional, as I mentioned, on treatment and behaviors. By contrast, Housing First pioneered in New York City by a Canadian psychologist called Sam Simberis, offered chronically homeless individuals rapid access to regular market apartments with independent supports. I'll talk about those in a minute. And so this idea that people no longer needed to go through the shelter system and then through various steps of transitional and short-term housing, but rather they could access regular apartments directly, was prima facie consistent with the idea that everyone has a moral claim to adequate housing. Housing First was also considered a principled approach. So here, this language of principles appears first in Housing First and then later in the Canadian National Housing Strategy. Some of the most influential principles, and I think we would agree these principles are broadly consistent with the dignity and the agency of the individual. They had consumer choice in choosing housing, both the style of the unit and the neighborhood in which it was located, and with any services that they would wish to engage with, for example, health and social services. There was a recovery orientation that supported individual priorities and harm reduction, a stark contrast to the emphasis on sobriety and a sort of a zero tolerance approach to alcohol and drug use that had previously prevailed in many places. It separated housing and services so that someone's housing security and tenure is not dependent upon the success of their interaction with services, or indeed any interaction at all. And it imposed minimal conditions on people entering the system, regular lease agreements, which in fact ensured that people had regular tenancy rights, including, at least some protection from evictions, meetings with staff, and contributing 30% of their income to rent. Typically, those incomes were extremely modest, and so the contribution to rent also modest. The difference was made up by rent subsidies provided by Housing First programs. Moving now to the Canadian context, Calgary and Edmonton were the first cities to adopt Housing First, and both of those cities located in the province of Alberta, where I work. And indeed, in 2008, Alberta was the first of Canada's 10 provinces to adopt Housing First in its housing strategy. And then by 2013, the Government of Canada endorsed and funded Housing First. From that point onwards, if communities and cities wish to address homelessness and they wish to receive federal funds, it was essentially required that they adopt a Housing First approach. And so in this time frame, which precedes the National Housing Strategy by at least 4 to 5 years, there was a proliferation of 10-year plans to end homelessness. These were the plans in which Housing First was embedded. And here's an example of the Edmonton plan from 2008, A Place to Call Home. And so there was really a great deal of optimism and positivity that Housing First could actually not just rehouse individuals, but end chronic homelessness as a phenomenon in Canadian cities. From a rights-based perspective, what can we say about the Housing First policy approach that proliferated in Canada and indeed many international jurisdictions at this time? On the positive side of things, it was founded on a belief that housing is a human right and not something that needs to be earned through, for example, compliance with treatment programs. It avoids or eschews moral judgments about who is deserving of housing. Indeed, its foundational premise is that everyone is deserving of housing, including some of society's poorest and most marginalized residents, people who have experienced long-term homelessness, often extending into years or even, in some cases, decades. And in both the academic literature and the policy documents around Housing First, it was often noted, albeit in passing, that it was a rights-based approach. This would often take the form of a single sentence in long articles or documents saying Housing First is consistent with or draws upon a rights-based approach, but that was really the beginning and the end of the engagement with the right to adequate housing, which I found rather unsatisfying. There was also, I think, some reasons for reservation, some limitations perhaps from a rights-based perspective. First of all, Housing First was adopted in large part because of its ability to reduce the public costs associated with chronic homelessness. Things such as extensive use of hospitals, reliance upon ambulances and emergency care, and expensive engagements with the criminal justice system and policing. So it was the idea of cost savings that attracted, at least in part, many jurisdictions to the Housing First model. Secondly, in terms of how it works, it's very open. It seeks to reintegrate homeless people into the market, right? So into regular market apartments, not initially relying on social or affordable housing, not demanding that more social and affordable housing be provided, rather making use of excess capacity in the market. Thirdly, it does not seek to prevent new cases of homelessness. It's largely a reactive policy system, moving people out of the homelessness they are already in. And lastly, it was argued by some scholars that Housing First intended to make homeless people more manageable by bringing them into a system of case management. I'm not sure how far we would want to go with that interpretation. I think there's some reasons for and against it. So then the third and final thing I'd like to do in the remaining 15 minutes or so is talk about the work that I have done with students in Edmonton, Alberta, evaluating housing first from a rights perspective. And here's the rationale for our two projects. First, to test the claim that housing first is based upon the principle of housing as a right. As I mentioned, this claim had often been made, but just in such fleeting detail, was a passing mention that didn't really engage with any of the literature, any of the foundational documents at the international level on what the right to housing is, why it's important, what it consists of. So, that was, I thought that was a claim that needed to be tested because it was often made, but never in any detail. And secondly, and perhaps more methodologically from a social science perspective, we wanted to demonstrate that housing first policies and programs can be systematically evaluated from a right to housing perspective. That the right to housing has this practical purchase, not just in the courts or in legal contexts, although that of course is very important, but also in the world of policy evaluation, of program evaluation, that the right to housing is, among other things, a tool, a normative and analytical tool that researchers can use to analyze what has been pursued in terms of policies and programs. So those were our overarching goals. So as I mentioned, there was two components to this project, the first of which was concerned with housing first policy. And here you can see the title of the article that was published in Housing Studies and my co-author. And of course, we seldom do things without the help of wonderful co-authors. And the specific questions we asked in this paper were, does housing first policy use rights language? And secondly, are state actors seeking to meet their international human rights commitments through housing first policy? And at this stage, these rights were only international. There was no recognition of the right to housing at the domestic level because this work preceded the national housing strategy. So the first question, then, quite a descriptive one, but one that no one had ever undertaken before. Are these policies, which are numerous and often, in long documents of 20, 30, 40 pages, do they even talk about rights? Do they include any rights language? So let's have a look at that. First of all, a brief note on our data set. We looked at all of the documents that were relevant to the Alberta context. 81 in total, 77 from municipalities, the Canadian word for city authorities, 3 from the province of Alberta, and 1 federal document. And the methods we used, which I'll be going through briefly, there's 2 methods, a keyword approach, and secondly, a more detailed and substantive content analysis. And so we'll be looking at that as well. But the keyword approach, as an initial way of gaining some understanding of the policy, was quite helpful through identifying and categorizing the words that are used quite simply. And so we started, as you might expect, by looking for the word right. This wasn't the only word we searched for, of course, but I think it's instructive and illustrative, as we shall hopefully see. So the word right appeared 184 times in these documents, which is 2.25 per document on average. And so that immediately tells us, right, these documents are not saturated with rights language. Rights are fairly infrequently mentioned relative to the size of the corpus. And we were able to break down these 184 references into 3 categories, which I think, again, is somewhat instructive. The first, right, is entitlement. This is the closest category to the classic understanding of the right to housing as a moral claim upon society's resources. Secondly, right as an correct, somewhat more pragmatic understanding of the word right, as an appropriate or efficient choice to make. And thirdly, one I won't dwell on too much, but right as immediacy. Here we think about in English at least, right away, right? Something that is urgent, something that should be undertaken without delay. And so a couple of quotes to provide some illustration of the way in which rights were used. So with regards to entitlement, the principle of HF, Housing First, is that every person has the right to a safe, secure home. And secondly, housing is viewed as a right of everyone within society and not a reward for clinical or programmatic success. So that second quote is really contrasting Housing First with the previous approaches to homelessness management in North American cities. And then secondly, slightly different, more, at least in a nuanced way, approach, right as in correct. Socially, morally, and ethically, it is the obligation of this community to do something, to do the right thing. So this is perhaps less about the entitlements of homeless people and more about the responsibilities, the duties of the community and its leadership. And secondly, a quote I hope you'll appreciate from the city of Calgary: helping people experiencing homelessness is ethically the right thing to do. But research also proves in many cases it costs less. So here we see the notion of right as in correct paired with the notion that it's also right because it's a cost-saving mechanism, it's more efficient, and it promises savings to the public purse. A much more conditional type of logic than right entitlement. The second part of our policy analysis, of course, moved beyond that initial passing of the documents to engage more with the substantive content. And here we were able to draw upon general comment number 4 from the United Nations Committee on Economic, Social and Cultural Rights. And I commend that document, and I refer you all to it if you're not already familiar, for the way in which it articulates the entitlements and duties associated with the right to housing. And all too often, I think there's an assumption that the right to housing lacks substantive content, that it's not a practical tool, that it's unwieldy, it's a vague moral statement. And I think general comment number 4 shows that that is absolutely not the case, that it does have quite specific, meaningful, substantive commitments, which are relatively easy to understand. And among those are the 7 essential components of right to adequate housing that are identified and clearly described in that document. And we argue, and others have argued, that that this framework provided an international standard for assessing housing policy. And so, although I use these components in the context of Edmonton, Canada, we would certainly believe and encourage others to adopt the same framework to analyze housing policies and programs in their jurisdictions, wherever they may be in the world. So 2 of the 7 components that we looked at were actually well acknowledged in policy. First of all, affordability. All jurisdictions that we looked at, municipal, provincial and federal, gave substantive attention to the issue of housing affordability. And they also committed themselves to increasing the supply of affordable housing as a way of addressing that problem. And I would say that, in Canada, there is a consensus that we do have a housing affordability crisis, and a consensus that the dominant way to respond to that is to increase supply of social and affordable housing, affordable market rentals. Those are exactly the units that people exiting homelessness need. Secondly, jurisdictions also gave at least some attention to cultural adequacy, and they acknowledged that it was not a one-size-fits-all policy, and that if Housing First was going to be successful for Indigenous peoples and for migrants to Canada, adaptations would be required. Secondly, there were also some components that went completely unrecognized. First here is location. So of course, as a geographer, this is one that really sticks with me. No jurisdictions considered where the housing that is used in these programs is located relative to sorts of services that people need to support their lives and to be successful, such as healthcare, childcare, education, and employment. And secondly, there was no consideration of the quality of housing, its habitability, despite the fact that the low end of the market rental sector, precisely the end that people working in housing first are most likely to be able to afford. There's known problems with quality, and these were not acknowledged or even referred to in passing in the documents. So, with about 5 minutes to go, the second and final part of my research program assessed housing first programs from a right to housing perspective, also published in Housing First with my colleague, former student Sophie Stadler. In this paper, we asked, do housing first programs provide an effective remedy to homelessness? And do those programs realize the right to housing in practice? So let's have a look at what we found. The data set involved interviews with key informants in Calgary, Edmonton, and Fort McMurray. Our informants were all people working in the housing first programs. This particular study did not include the clients, the recipients of those services, although certainly that would be worthwhile research, absolutely. We spoke with 14 organizations for a total of 21 participants, and we evaluated our data against 4 housing rights principles, 2 of which I will showcase in the coming slides, but there was more than just 2 that I'll be looking at. So let's have a look at what we found when we began to examine housing first programs, the actual practices on the ground that connect chronically homeless people with housing and independent services. First of all, the principle of non-discrimination. We found that all of the programs in the 3 cities we looked at used a standardized assessment tool to determine the eligibility of clients, to bring them into a computer system, and to assess their priority. And so because that tool was standardized and was used in the same way in all places, it did not provide any potential concerns around discrimination. However, because of the limited capacity of the programs and the limited number of affordable units they could access, they were required to create a waiting list, and the place that someone was put on that waiting list was a measure of how acute their circumstances were. What that meant was that being chronic homeless was not in itself sufficient for timely access to housing. Rather, it would put you on a waiting list, and if you were towards the bottom of that waiting list, if you were not considered one of the most acute cases, then you would be waiting months and potentially up to 2 years to be rehoused. And so certainly that is where the question of discrimination might come in, because a right delayed is a right denied, perhaps. There is no right in practice to timely access to housing through housing first programs. Moreover, we see that when housing first programs interact with the private rental sector, which is where they access their units, is when they encounter other forms of discrimination. They found that private sector landlords, including large institutional landlords, definitely discriminated against their clients, the people they were attempting to rehouse. And it did so on the grounds of housing status, i.e., they wouldn't accept people who are currently homeless, the race or ethnicity of homeless clients, many of whom are either Indigenous or of minority migrant backgrounds, and source of income, which is often social assistance or welfare payments. All 3 forms of discrimination are in fact illegal in Alberta, but this did not prevent them from being widespread. And a little quote, one major landlord refused to accept housing first tenants by associating them with crime and claiming we're going to crime-free buildings. So a rather unpleasant assumption to make, and certainly one that can effectively deny people their right to housing. The second principle that we looked at was adequate progress. So are housing first programs ensuring that people who were homeless are on a pathway to secure, affordable, and permanent housing? Overall, there were some positive things to say. Programs took an active role in measuring clients' progress, both their housing stability and their personal goals. And if someone was evicted, they would rehouse them in a different apartment. Units were inspected for quality at move-in time and needed to meet all regular adequacy and safety standards. They were described as run-of-the-mill apartments that anyone else would rent, maybe that you or I might rent. However, in terms of achieving adequate progress, there was this constraint that there were relatively few units on the market, and even fewer were accessible for people with mobility impairments or other types of disabilities. And of course, people who have been experiencing long-term homelessness are more likely than other members of the population to have impairments and disabilities due to the hardships that they have encountered. So discussion and conclusion in the remaining 2 minutes. On the topic of policies, we found a very limited engagement with rights. References to rights were not numerous. As I mentioned, 2.25 per document on average. And where these references did exist, they were often single sentence assertions, which is actually very similar to the academic literature on housing first, which again made those passing references. There was no detailed consideration of why housing is a right or why homelessness is a breach of that right. And it understood homelessness as an affordability issue, which I guess it absolutely is. It's a fantastic starting point, but it neglected many other components of the right to adequate housing. Despite the weak policy foundation, we found that Housing First programs were actually much more compliant with the right to housing. People were aware of this right, they were seeking to advance it, and they were certainly protective of the dignity of the people they worked with. However, the constraints and the limitations on adopting a rights-based approach basically came when Housing First programs had to interact with the private rental sector, where they found very limited stock available, which contributed to these long waiting lists and the need to triage people according to their level of need. They encountered affordability constraints, discrimination from landlords, and as I mentioned, a lack of accessible units, which is concerning because accessible units are exactly what many people exiting homelessness need to secure their right to adequate housing. So, final slide. What are some takeaway points from my presentation to you this evening, and hopefully some prompts for questions? First, the human right to adequate housing has received long overdue legal and social recognition in Canada. I mention the social because I think that the way in which we think about housing issues in Canada has changed. For the first time, we now see that a right to housing perspective is very much part of those conversations. And we have strong advocates for the right to housing working at many levels in Canada, including at the federal level under the National Housing Strategy. The right to housing is not only a legal framework, though that is of course very important, it's also a normative and analytical theoretical tool for housing scholars. We can, and I would argue we should, use the right to housing to assess housing policies and programs. I think we can be vigorous and we can be careful, and we can produce high quality research using a human rights perspective, and we can really one of our roles, I think, as scholars is to try and hold the state to it, and to point out where there are limitations. And finally, I think there's definitely a case that both scholarship and policy needs to engage more meaningfully with the right. These simple assertions that something is consistent with the right to housing, they are no longer sufficient if they ever were, right? We need to move beyond the sentence passing mentions of housing at all levels in policy and in academic practice. And I guess my parting message, the need to take the human right to housing seriously. So with that complete, I will exit the screen sharing here and come over and see you on the other screen.
Thank you very much, Damien. Very interesting presentation. We have now some time for questions and discussion. So I encourage you to open your mic and formulate the questions as the chat. Sometimes it's a little bit complicated to follow the debates there. So if there is any question, just please feel free and begin.
Yes, hi. Am I allowed to ask a question, Andre?
Yes, please. Go on.
Thank you. Thank you for your presentation. My name is Michelle Bruin, and I'm also working with projects. Very fascinating and very interesting presentation. Also very interesting to learn a little bit more about the Canadian context and how the Housing First program works. I definitely recognize a lot of issues that you run into in Canada that we face in the Netherlands as well, especially when you quoted like the landlord, I don't want to house criminals. We exactly the same issues, but then with housing associations in the Netherlands, because it's housing associations are more like semi-government organizations and not as the same as public housing in Canada or the United States. But I was wondering, does the Housing First program also include specific rules on tenure security? Because I can imagine this is a very vulnerable group. So even if once they're housed, they also maybe need like special tenure security.
Great question, thank you. And so I'm happy to describe that. So when Housing First programs, when they have a new client who's entering housing, the client will sign a regular lease, a regular tenancy agreement with the landlord. And so it's sort of it's normalizing. It's the same lease that every other renter in the province of Alberta signs, and it gives regular tenancy rights to the renter, as well as responsibilities for the property, of course. And it also limits the authority or the power of the landlord. For example, they can only evict under certain circumstances, and they have to follow a process. So certainly Housing First tenants receive regular tenancy rights, and that was generally perceived as a positive thing, that it was sort of a normalizing process. And so that was on the legal side of things, I guess. The second thing, in terms of the practices, Housing First programs would often intervene or try to assist if there was a problem in the tenancy. If there was a dispute between the tenant and the landlord, they would seek to mediate that to resolve the dispute or the tension, with the idea of trying to protect the tenancy so that the person wouldn't be evicted. So there were sort of the two components, the tenancy agreement and then the social supports and the cooperation there. Having said that, evictions certainly do occur, and when that's the case, the Housing First programs will seek to find the person a new apartment. So there's that's a third level of protection, perhaps.
Wow, interesting. Thank you.
Thank you very much. We still have some more time for other questions, so if there's anyone who would like to ask, just open the mic or the camera. Meanwhile, I would like to formulate a question myself. I was thinking of the approach in Canada is based on a collaboration with private actors through rentals in the private market. I was wondering if those housing policies. Okay, I am seeing that apparently my mic is not working. Thank you. Okay, is it working any better? No? Okay. I will try one last thing. Okay, any improvement on the now? Okay, thank you. I was saying, if there is any other question, please feel free to open the mic and formulate the questions. Or open your camera as well, and we can see. Otherwise, meanwhile, you are considering any question for the speaker, I would like to pose myself one, Damien. I was interested in the approach. I see the Canadian administrations have articulated that housing policy through rentals in the private market. And I was wondering if those policies have also came with any obligations that constrain the right to property of those landlords involved in the program, or if it was only supported by public expenditure or public funding. Because I am thinking of other countries, particularly the case of Spain that I have studied, and in some other places, administrations experimenting with housing first policies through the imposition of obligations on private landlords have precisely, I think, taken an approach more rooted or more based on a right-based approach, precisely to justify that intervention on property. So I was wondering how was articulated in the case of Canada, and whether maybe that could also explain that lack of mention to rights in the policies.
Question. Thank you very much. And so the short answer is no, as you might have thought, perhaps. So certainly no obligations imposed on landlords, part of the program, above and beyond the standard obligations that they have to any tenant. And as I mentioned, standard tenancy agreements apply, so there's sort of no special rules or requirements here. And so I think that the idea that extra obligations would be imposed on landlords is somewhat foreign, would be somewhat controversial, perhaps, in Canada and the United States, because it's such a market-led system. Market actors have power and authority, and any attempt to constrain that authority is met with resistance. For example, rent caps, would be an example of something that is resisted and often pretty absent or ineffective because of the power of private landlords. So that's the short answer. The other thing I would say is, housing can work quite well when there are vacancies in the private market. Landlords need people to fill empty units. They need the rent that comes with housing for clients. They can be quite cooperative. However, when vacancy rates are low and landlords can be more choosy about who they accept, that's when the discrimination becomes more apparent. And also there's just fewer and fewer units for housing first programs to access because the vacancy rates are so low.
Thank you. Interesting. Okay. Is there any other question? Just feel free to intervene.
Hi, my name is Maria Aldanas. I work for FIANSA, the European Federation of National Organizations Working with the Homeless. As you probably know, we have tried to promote the housing first approach in Europe, and we did a housing first guide, like trying to look at the core principles of housing first, and we decided that housing is a human right was one of the first core principles. So we included there the definition of the right to housing by the UN Committee on Economic, Social and Cultural Rights, so including the different elements of the right to housing, trying to connect it also with the European typology of homelessness. But I have the impression that we are in a moment where we're looking at it in a different way, like looking at housing first. That we hear some voices saying that the human rights-based approach is not engaging enough, that it's not gaining traction in many countries. And some people prefer like a kind of a pragmatic approach, focusing more on the housing solutions for the homeless. That could be housing-led or housing first. And I just feel that we need to underline the wider kind of objectives that the right to housing has in connection with other public policies, with not just housing policies, but also other public policies. I'm thinking about preventive policies. So the solution to homelessness will not be just on housing first, but it would be all the different public policies, preventive policies that would social housing, including social housing, that would help people getting out of homelessness. I don't know if I'm making myself clear, but I have the impression that after 30 years, as you said, Housing First has not solved homelessness. It has not solved homelessness for those who are worse off, those who are with higher needs, thinking in terms of people with mental health problems and with drug abuse, etc. But I see discrimination in a way right now when a lot of the allocation of public programs go to Housing First, and other groups that should be needing those housing and those housing units, both in the rental market and in the social housing sector, they're not getting that because Housing First is taking all the space. Maybe I'm being a bit I don't know, open. It's a really open question, but I would like to have your opinion on these several things. Damien, thank you for your presentation, by the way.
Thank you, Maria. I certainly agree with many of the things you're saying. I'll just make two brief comments in reply. First, I think you're absolutely right. We have learned the limitations of Housing First. That in fact, although it only can help individuals and has rehoused people successfully, it has not ended homelessness as a phenomenon, as a social and economic problem. It persists even after 30 years. So we've seen the limitations of Housing First. It will not solve homelessness by itself, and it should not monopolize public funds. It should not be the only group. I think it should be part of a suite of policies, certainly including the social housing alongside that. And secondly, the right to housing, I think you alluded to this, shouldn't be constellation. It should be connected to other rights, like the right to health, for example, would be one that's obviously connected. And it should be considered in its fullest extent, not as a narrow right, but as one that is broad and that is really about the relationship between people and society. So I think there's a lot to be said for that. So I certainly agree with all the points that you made.
Thank you very much. Unfortunately, we ran out of time, so thank you very much for joining today. Thank you very much, Damien, for the interesting presentation and the discussion. We are closing this event for today, but please keep an eye on your email because we will be hosting the next EVIC talk the 29th of February. So please keep an eye on your email and see you soon. Thank you very much.
Bye. Thank you.